Hey guys, welcome back to today's video. We've got 2 courtroom hearings to break down, including a fresh update on a defendant who recently had a major meltdown in court. This is the same man accused of stealing a package from someone else's porch, and if you remember our last video, things got completely out of control when he screamed and cursed at the judge, earning himself an extra 6 months behind bars. Now, there's another update in the case, so let's jump right into it.
State, would you please set a record for James Broadway?
Yes, Your Honor. Thank you. This is State of Indiana versus James Broadway. There are 2 cause numbers, 64D01-2602F61333 and 64D01-2602F61636. The defendant is present in court in person by video conferencing without counsel. State of Indiana by Gary Gurman.
Morning, Mr. Broadway. Can you hear me okay? So first, I'm required to advise you of your various rights in this matter. You have the right to hire an attorney to represent you. You have the right to have an attorney appointed to represent you if you cannot afford an attorney. You have the right to a public and speedy trial by jury, and you have the right against self-incrimination. That means you could not be forced to make any statement or testify against yourself at any hearing or trial held in this matter. You understand those rights as I've just gone through them?
Sure.
Okay, and you've been charged here in F61333 with 1 count. This cause states that on or about February 4th, 2026 in Porter County, you did knowingly or intentionally, it's actually on February 5th, 2026 in Porter County, that you did knowingly or intentionally exert unauthorized control over a Laura Geller Compact Foundation belonging to a Jennifer Badola by taking the package from her porch and with the intent to deprive her of any part of the property's value or use. And that upon a criminal records check, law enforcement determined that you have a prior unrelated conviction for theft or conversion from 2018 in Porter County. You understand the allegation?
Yes, I returned that package to.
Sir, do you understand what they allege you did?
Yes, and I returned it to the police officer, and he said he was not going to charge me with anything.
What's important for me to know is that you understand what they allege.
Yes.
Okay. And it's charged as a level 6 felony, which carries a possible sentence of 6 months to 2.5 years in prison and up to a $10,000 fine. You understand that possible penalty?
Yes, I want to go pro se.
Okay, let me get into the next part first.
But I just
First, I'm going to enter a preliminary plea of not guilty for you on count 1. And then the state filed on February 25th a habitual offender enhancement. Have you received a copy of that?
I haven't received nothing. Can I say something?
Go ahead.
This case that you're talking about is a summons for March 20th. We're not even talking about why I'm here when I got transferred. That's what I don't understand. That's why I fired off at you.
Yeah, I understand, Mr. Broadway. Like I explained the first time we met, the summons went out, but because you were already in jail, they wanted to make things convenient. So they just wanted me to do the initial hearing while you were already in custody, which was fine with me. So the February, what was it, 20th or whatever date the summons date was, that was vacated. March 20th. So you don't have to be here on March 20th. That date was vacated.
That means your speedy trial is something that I'm still talking about why I'm here. From Speedway and the possession charge was Clymer transferred me to you for that charge. And none of that is being discussed right now. I have 3 different cases going on. I got a Toadies case with false informing, and we got pulled. We didn't even get pulled over. We ran out of gas, and they said they were going to help us. And then now I came here, got re-OR'd, I'm say. So I just want to go home, sir.
Well, that's not happening anytime soon. Not until you finish serving the 6-month sentence you earned for contempt of court. After last time's explosive courtroom outburst, the judge made it crystal clear that your actions came with serious consequences. And now you'll be spending the next several months behind bars before anything else moves forward in this case.
And we
I
can do
understand, Mr. Broadway. You keep doing a couple things which you need to stop doing. One is that you keep talking about your defenses out loud in front of the prosecutor. You should not do that. You should only talk to about your defenses in front of your attorney. If you're going to represent yourself, you need to do that in some proceeding other than in front of me, because I don't need to hear any defenses until your cases go to trial. You talked about the pending case you have in front of Judge Tody. I'm aware of that. You've got the pending matter in front of Judge Tody. That's why when I'm done with the hearings that I have to complete with you today, I'm going to transfer your case to Judge Tody because he's got cases. Also, Judge Clymer transferred your case to me. I should never have had that case. It should have gone to Judge Tody because he's got the pending case, the first pending case, okay?
I understand. Thank you.
You were in jail already on F61636, which was the case that came to me from Judge Clymer, right?
No, I was not.
You were. They arrested you. You were in jail.
Sir, I got a summons by the officer. He told me that he was not going to press charges against me if I returned said package. I did that.
Okay.
The next, hold up.
I'm talking about one case. You're talking about the other case. But in
No,
any event,
you're talking about the March 20th package. I'm in here for Speedway, taking food out of Speedway and having a box that was in my pocket that I found.
That may have been why you were arrested, Mr. Broadway, and I'm not going to disagree with you. That may have been why you were arrested on F61636. You were already in jail for that, and then they saw that you needed to have the initial in F6133, and to make matters easy, they brought you in front of me last Thursday so we could do the initial hearing on that.
But that's not stating why I'm here. This case, why I'm here, is not what you're talking about. But what I'm saying is the officer said he was not going to press charges if I gave him the said package. I gave it to him. The next day, and my door was even open, and it had a piece of plastic.
Broadway, I need to get through one more part, okay? You keep talking about your defenses. It does not help you.
I'm not. I just want to go home, sir. I keep getting set up to be here, and people get let out of here that has worse charges than me. And
Mr. Broadway, I need to go through the habitual enhancement notice with you as well. You have been filed. The state has filed a habitual offender enhancement notice on February 24th, 2026. I would like to go through it with you. It says that on or about October 7th, 2024, here in Porter County, you were convicted of a felony in 64D02 2406 F6 6181, maintaining a common nuisance, which occurred on June 5th, 2024, and that based on that conviction, you were sentenced on October 7th, 2024 to 360 days in the Porter County Jail, which was suspended. They also say that on June 25th, 2018, in Porter Superior Court 6, you were convicted of auto theft in 64D06 1801 F6 603, which was committed on January 18th, 2018, and that based upon that conviction, you were sentenced on June 25th, 2018 to 365 days in the Porter County Jail. They also say that on January the 6th, 2012, in Porter County, you were convicted of a felony in case 64D01 1108 FD 7679, intimidation, a Class D felony committed on August 12th, 2011, and that based upon that conviction, were sentenced on January the 6th, 2012 to time served in the Porter County Jail. They also say that on December the 1st, 2003, in Porter County, you were convicted of a felony in cause 64D01 0010 DF 8173, possession of marijuana, a Class D felony, which occurred on 26th of September 2000, and that based on that conviction, you were sentenced on December 1st, 2003 to time served in the Porter County Jail. Do you understand what they allege are your prior convictions related to the habitual offender enhancement notice. Do you understand what they allege?
No, I don't. That's not my charges. That's not me. My name is Jamie Clifford Broadway. Not James Clifford Broadway. Jamie Clifford Broadway.
Oh, so now we're going with the classic, it wasn't me, it was my brother defense. That might have sounded believable for a second, if there wasn't already video footage of you admitting you were the exact person they're accusing. And that's the problem here. The evidence doesn't forget. Just when he thought he had created a clever excuse, the courtroom was reminded that the confession had already been caught on camera, completely destroying his story in seconds.
My name is Jamie Clifford Broadway. Get that right. My name was changed when we came back from the war.
30 days.
So, according to your own statement, assuming we're even accepting your version of events, your name used to be James Broadway before you changed it to Jamie Broadway. In other words, it's essentially the same identity with only a slight change in the name. The court wasn't exactly convinced that swapping James for Jamie suddenly made you a completely different person, especially when everything else pointed back to you anyway.
Okay, sir.
Explain
That's
that.
what the state alleges for the habitual offender enhancement notice.
You
You understand what they allege?
I understand that. I hear that, but
Okay.
I don't agree with it.
I understand, and nobody's gonna. In a few minutes, I'll enter a not guilty plea for you on it because you're innocent until proven guilty in this country. I need you to understand that the possible sentence related to the habitual offender enhancement is that you could have an extra 2 to 6 years if you're convicted of a level 6 felony, 2 to 6 years additional term, and it's a non-suspendable additional term. Okay? So if you're found to be a habitual offender, an additional fixed term between 2 to 6 years for level 6 felony can be imposed at the time of sentencing. Do you understand the possible penalty?
I do, and
Okay, that's all I need. And as required by statute, the court will enter a preliminary plea of not guilty for you on the habitual offender enhancement. Now, I'm transferring your case to
Okay.
DO6. Both of these cases get transferred to Judge Tody, and you have a hearing set with him on June the 15th at 8:30. So you'll be back in front of him on June the 15th at 8:30. And you should have copies of the order that I signed yesterday, or I'll sign today if I haven't signed it. That is the sentence for the contempt finding. I found you guilty of contempt last Friday, and I sentenced you to 6 months in the Porter County Jail. That's another reason why you'll be sitting in the Porter County Jail until the June 15th.
Well, then I can't go pro se like I got escorted out of your room because I I don't want to look like this in the courtroom. I want to presume I got court.
You said you want to proceed
I
pro
got court
se.
clothes at home that I was ready for court.
You said you want to proceed pro se.
Like
If you
this,
want to
I
proceed
don't
pro
understand why
se,
you can't OR me and I be in court with my suit or tie.
and he will have to conduct a Feretta hearing related to the pro se. But in the meantime, I believe I have a duty to make sure you have an attorney within 20 days of being arrested.
I don't want an attorney,
And
sir.
I'm going to appoint the Porter County Public Defender Service
I
for
don't
you.
want that. I'm my own attorney. You know that. So does Judge Tody.
I don't
It's
think
so
you can get through
simple.
a Feretta
It
hearing,
is so
sir.
simple. I'm not a flight risk. You all know where I live at. I'm
Well,
sorry
you're
for
in jail
raising
now
my
because
voice,
I sentenced
but
you
I'm always put as a
6 months
different in this place.
for your contempt last Friday.
I
transferring the
don't
case.
call
We
that
have a
being.
hearing on June the
You said
15th.
something about
Go
chickens,
to
sir.
Judge Cody.
That is
and
not
we're adjourned.
professional.
We're adjourned, sir.
Well, that wraps up that disaster of a hearing. And honestly, I'm not sure you're exactly qualified to lecture anyone on judicial professionalism after the way you acted in court. Still, enjoy the 6 months in jail. Now, with that chaos behind us, we move on to our next defendant. A man now facing assault charges after allegedly attacking store employees for doing something completely unreasonable in his mind. asking him to actually pay for the items he was trying to steal.
Portal call, People versus Ryan Wagster, 26 CR 323. Hello, sir. Are you Ryan Wagster?
Yes, sir, I am.
Did you understand your rights in the advisement?
Yes,
Have you ever been in the U.S. military?
no,
Charges are third degree. Actually, it looks like maybe the charges are still being decided. But allegations are third degree assault and attempted robbery. Do you understand the nature of the allegations?
yes,
I reviewed the affidavit. I found probable cause for the arrest. I will issue the protection order. This is a VRA matter. Do not harass, molest, intimidate, retaliate against, or tamper with any victim or witness. Vacate the home of the victim. Stay away from the home of the victim, but also stay away from any location that the victim might be found. No contact whatsoever, and do not directly or indirectly communicate with the victim. No contact whatsoever. Based on the fact that this occurred at her business, Ms. O'Hara, even if I did know the home address, I would not list it. Any quarrel with that?
No, Your Honor.
All right, bond argument, Ms. O'Hara?
Your Honor, the defendant does have a very lengthy criminal history dating back into the 90s, and it does include felony attempted second-degree assault, attempted burglary, a menacing as a felony, a second-degree assault as a felony, along with other misdemeanors on his record, thefts, harassments, violation of protection orders, things of that nature. Obviously, the facts of this case are very concerning to the people based upon the fact that the victim in this matter, as well as Mr. Perez, were simply doing their job and working at the Family Dollar, and were attempting to confront the defendant about the potential for a theft when the defendant punched the victim. So obviously that is very concerning and it's an extremely aggravated case, I guess. It went from what could have been a simple theft to now something much more serious, and it could be something even more serious. I don't know the extent of the injuries to the victim, if there was anything more substantial. But based upon all of that, I am asking for a $25,000 cash or surety bond with pretrial.
Bond argument, Mr. Duran?
Thank you, Judge. What I can say, as the court's well aware, is that this case is alleged to have been from May of 2025, and there was, it appears, recent identification attempts based on the detectives from Greeley Police Department in the affidavit. What I can say is there hasn't been additional cases or law enforcement contact or anything at this time. As far as we know, Mr. Wagster was compliant with officers. I can say that most of what the district attorney noted in the argument were, from what I could see, misdemeanor, previous criminal history, unrelated previous criminal history to this type of charge, and as she noted, relatively old. I can also say that Mr. Wagster lives in a house here in Greeley that he owns. He's going through a lot with that home, though. Someone apparently tried to quitclaim the deed for the home illegally, and Greeley Police is investigating that on behalf of Mr. Wagster. He lives by himself. He has a dog that's currently staying in the home that's not cared for because he's not there. He's taking care of his neighbors, and he's working on getting approved as their permanent in-home caregiver. He does have transportation to be able to make it to and from his court dates. He is okay complying with pretrial services and GPS monitoring for the court. The parties can't see it. He had a case in Denver that was dismissed and sealed 2 weeks ago where he was compliant on pretrial services. And he's willing to do that again. Obviously, this came as a complete surprise to him, given the age of the case, and not knowing about the warrant. But he's willing to do everything he can to be successful on bond. We are asking the court to consider a personal recognizance bond. He has no issues with any protection orders the court may set here.
That's going to be a hard no, especially considering it's been months since the alleged assault took place, and only now is he finally deciding to address charges he clearly knew were waiting for him. From the court's perspective, disappearing for months and then suddenly showing up doesn't exactly help your credibility, particularly when the case has already been hanging over your head the entire time.
Well, he may have thought that whatever the issues were, they were put to rest. So I don't know if I agree with complete surprise. It's just that it came now is probably not all that convenient, but he could have stuck around, assuming it was him and this really happened. He could have dealt with the police then. So I don't reward someone for basically remaining at large for 8 months on something where he's alleged to have basically hit somebody because they had the audacity to ask him, are you going to pay for that? And really elevates in about one short 2-second decision what's probably a petty shoplifting theft in a municipal court into much more serious charges against his backdrop. And I don't know if what you were trying to say is you don't think he has prior felonies, because it looks to me like there was a prior burglary and a stint in DOC. That by definition would be a felony. I certainly understand it's less convenient now for him. But to me, that doesn't garner any points for him, that he hasn't committed any other offenses or we would have caught him sooner. So this caught up to him now. That's just the way it is. This is more than your run-of-the-mill third-degree assault. Court is going to set bond the amount of $25,000 cash or surety with pretrial services, monitored sobriety, appear at all future court dates. To comply with the
Mr.
mandatory
Waxer.
protection order. Do not violate state, federal, or municipal laws. What's that, sir?
Can I say something here?
Can I say something here? Sure, you can speak, but just because you can do something doesn't mean it's a good idea. You could also jump off a tall cliff without a parachute, and that would end about as well as some of the decisions being made in this courtroom. The judge's point was clear. Sometimes staying quiet is the smartest move you can make, especially when every word coming out of your mouth is only making the situation worse.
I mean,
Mr. Waxter, Mr. Waxter, Mr. Waxter, Mr. Waxter.
You had your chance to say something. I have something to say here. This is not fair. You're making it sound like I was on the run and evading everything. This wasn't even filed until Tuesday. I had no idea that this even existed. I mean, you're making it sound like I was evading and running everywhere. And I don't even know what this is going on. This is not fair, Your Honor.
Okay. Well, your attorney can take it from there. If you don't want the public defender, you can hire your own attorney. Return of charges February 24th at 3:30 in the clerk's office. If you bond out, March 2nd at 3:30, you'll be in front of the district court. You can certainly lay that out to them. You have a long criminal history, and these are pretty serious allegations. So that's where we are today. That's it for today. Thank you.
Fuck you, Dwayne.
I got paperwork for you.
Thank you. Have a good weekend.
You as well.
Hey, come back over here.
This is fucking bullshit, bro. You heard what he just said, right? That I was evading and running for a year. They didn't even file these charges until Tuesday. I don't even know what they're talking about, bro.
Just come in here and have a seat so I get the protection.
I don't even know what they're fucking talking about, man. Fuck that dude, man. You want to see?
Thank you.
All right, guys, that's going to wrap up today's video. I'm still trying to track down the chicken guy's next court appearance, and as for the second defendant, he actually had a hearing scheduled just a few days ago, but I haven't been able to find any updates on it yet. That usually means one of two things. Either the court date was postponed, or he bonded out and decided not to show up. Either way, I'll definitely be keeping an eye on both of these courtroom disasters because, at this point, they're an endless source of chaos and comedy. If you enjoyed the video, make sure to hit the like button. If you didn't, feel free to hit dislike. But either way, drop a comment below and subscribe with notifications turned on so you don't miss any future uploads.